judgment of this Raji bench of the Patna High Court with regard to which it has been held by.
Give me the judgment. First give me the judgment and then you can take it. Citation. Citation.
Citation is my lord 1990 PLA.
1990.
PLA.
1990.
Volume 1, page 61.
Volume 1, page
61.
61. Jharkhand. Sorry, Patna.
Ranchi bench.
Patna
Yeah.
High Court, Ranchi bench. What is the ratio of this judgment?
That's Rule 3 is required to be considered.
So,
And thereafter, this matter again came up before this court in Jharkhand High Court. Before the full bench.
which is a paragraph?
Paragraph
Which
of-
paragraph of this
This is
judgment?
issue para 6, 7 and 8.
Para 6.
Para 6.
Please read it.
It's,
This is regarding maximum increase. We are not bothered about it.
no. I'm reading that provision. 7 and 8 paragraph.
Para
Control-
6 also.
Yes. Controller is, I'm reading the placitum portion and
No,
there are,
please don't read from the placitum, you read from the paragraph. Para 6, you read para 6.
yes.
Read it, please. This is regarding the rate and the manner to the extent it can be enhanced. This has nothing to do with natural justice or parties to be heard. Gave a cut-off date and to the extent of 25% with respect
Yes,
to the rent.
yes.
So that is absolutely redundant. We are well aware of this. So that they cannot say that it cannot be enhanced to such an extent. That is not permissible for them.
Yes.
So that is not their case also.
No,
They are not
that-
arguing it.
Otherwise, my lord, there is no judgment in the.
No judgment, just so there has to be a judgment now. Okay.
But the full page judgment that is reported in 2003 volume 3 ACR, page 536.
2003 volume 3 JCR
536.
536. Para number?
That is 16, 17, 18, 19.
Para 16.
And para 11 is with regard to para 11 then not necessary because the Balika Shiksha Bhavan's case is not relevant in this case, therefore I am not reading para 11. But 16, 17, 18, 19 says that once it has been decided by the House Control, confirmed by the Appellate Court and Revisional Court, High Court need not to interfere.
So writ is not maintainable. It
Therefore,
says that writ petition is not maintainable.
no, petition is not maintainable, ऐसा नहीं कहा. लेकिन it has been discussed that once
Certainly,
the three courts.
that's right. 4 court, 5 court के बाद भी Supreme Court interfere करता है, right? So that is not the principle. The principle is that the court should be very slow and see whether the order has been rightly passed or not. Unless there is something grave illegality or grave violation of any provision, then only there is a question of interference, isn't it?
One fact is here, which is not available on the record, but it is available that premises has been vacated, and that portion has already been demolished. Therefore,
So do you want to say that portion has been demolished?
yes.
Do you want to say that you waive off the rent?
No.
Then-
I am not waiving the right. I am asking that at the present there is nothing. assessment is to be or inquiry, fresh inquiry.
No, we are not asking for fresh inquiry. There is a report, he will have a say on that. We are not asking for fresh inquiry.
Then nothing to say.
He will have a say, whatever he has to say, he will say.
Then nothing to say.
If I am not wrong, Your Lordship, sir, observe tentatively that when an inquiry is committed for the purpose of evaluation of the rent of the area,
And also the condition of the premises.
condition of the premises, whether the both parties should be present or not, whether such an inquiry is permissible.
No, there are two stages.
Yes, two stages. First stage is this.
One is this. Second is that his main grievance is that at any point of time the copy of the inquiry report was not provided to him.
My lord.
Once that inquiry report comes to the court, it is for the court to offer the inquiry report to the parties
To file an objection.
to file any objection.
Correct.
Right. So at any stage,
My lord.
at the stage of ordering inquiry, at the stage of on-the-spot inquiry, and at the stage of adjudication.
That so far as the first two stages are concerned, they may not have an absolute right to say. But the third stage, Your Lordship's view appears to me also to be a very reasonable view that once you have a report against, not against or for, but if a party wants to object, he must have an opportunity to object. Because if you're using something against me, I must be given a right of notice, right of being object. But my only grievance, not observations, are coming to the facts. Even if that is the law, let me assume that is the legal position. Their objections opportunity has been denied. They have not.
And they are also harping upon it that the entire the inquiry, admittedly we have seen the records that the inquiry was directed in their absence. Inquiry.
They appear they didn't.
No. That is not.
That inquiry order, I think, that is a collection of evidence for the purposes of only a particular part, So they may not have a right to be aware of that. But once that comes, my only grievance with their conduct is this. So, I will take it that the report came, they were not given the copy of the report, and judgment was passed. This is a violation of principles of natural justice. But in appeal and revision, except for stating that this has not been done, in a case of this nature, which is now dragging on for almost 8 to 10 years, what is the prejudice caused to them? They ought to have. I am invoking the doctrine of theory of prejudice to say that are you bringing something contrary and saying that look here, had you given me an opportunity, I would have shown that it is not 10,000, it is 5,000. Because after such a long time, sending me back, kindly appreciate my position also. I have gone to a court. Now there is a procedural lapse. Is it so grave that it will wipe off everything?
That procedural lapse has been raised by them right at the threshold.
Correct.
If the authorities do not consider that procedural lapse, and you see the report, the condition of the premises itself is required to be brought in by making any recommendation.
Today that will not be possible.
That will not be possible.
I'm saying something in appeal should have, except for saying that they have not followed the bylaw. You should have seen the appellate order who has set out the grounds for appeal. And the first ground they have taken at page 23 is ये कि अनुमंडल पदाधिकारी सब भवन नियंत्रक पदाधिकारी गिरडी के न्यायालय के द्वारा प्रथम पक्ष के नाम से किसी प्रकार का नोटिस निर्गत किए बिना द्वितीय पक्ष के विज्ञ अधिवक्ता द्वारा प्रस्तुत तर्क के आधार पर अंचल अधिकारी गिरडी को प्रश्नगत मकान के किराए को बाजार मूल्य के आधार पर तय करने से संबंधित आदेश निर्गत किया गया। अंचल अधिकारी ने भी प्रथम पक्ष को बिना नोटिस निर्गत किए तथा प्रथम पक्ष के प्रश्नगत मकान का बाजार मूल्य के किराया निर्धारण संबंधी तथ्य के बिना जानकारी दिए ही अनुमंडल पदाधिकारी सोएंसो को प्रतिवेदन प्रेषित किया गया। तत्पश्चात सोएंसो ने प्रश्नगत मकान का मासिक किराया 10,000 रुपये। I am only saying that if you are objecting to this in the appellate court, did you say that no, it is not the market value? The market value is not 10,000, it is 8,000. These are the people who are staying in the vicinity, they are paying this. Because he has no role to play in that inquiry when a report is called for from the circle officer. And apart from that, the original order also notes that the area where the location of the building is a prime location.
This is not in dispute.
This is not in dispute. So I am saying it is not the sole consideration, but there are other considerations also. They must also say that I am taking what is the rent that they were paying is 2500 नहीं 1500 जो 2500 बढ़ाकर 2500 किया गया, कुछ तो एक बड़ा होगा. Some bona fides must come from their side also. Now hanging on to a technical objection, they are not making any concession that okay, it is not 10,000, it should be 5,000. You must also admit to something which is there. It is not that the rent has not increased at all. So you have to balance equities. I am saying sending it back today may not serve anyone's purpose. Lordship may consider the entire thing, lay down the law that yes, at a particular point of time, my submission is, and I completely bow down, that after a report has come of this nature, it must be supplied to the party to filing objection. To that extent,
And even at the stage of report, don't you think? Even at
Well,
the stage of
that-
report, because ultimately the premises is also required to be inspected.
Yes, that
the amenities available in the premises is also required to be seen as per the rules. And then,
but that may not
and then
require
it
his
has to-
presence. That may not require his
how
presence.
will anybody enter his
Oh
premises?
yes, certainly. Then if it is his premises, he will enter.
Therefore, after all, it is a tenant's premises which has to be
but
seen.
that is implied. That is implied that if an inspection of physical verification is required, they will have to be taken into confidence. Informed.
And therefore, the landlord, whatever he's presenting or whatever the circle officer is collecting, he also needs assistance on the spot. That what all are the premises available.
I
So
agree.
these things.
So these things are no. I'm saying these are inbuilt. These checks and balances are inbuilt in this
But
type.
the point is that he says that as of now, the building does not exist.
Does not exist.
And he has been evicted. He admits that he has been evicted.
He has been
from the
evicted because
premises.
I am the person who is the beneficiary of the order. I have sold the property to them of 2019. So anything after their sale, they are entitled. Before their sale, I am entitled. I am a person of who is now aged about 80 plus. Because I have said 73 in 2019, so we'll add 5, 78 years old. I think we have left this place also
So
irritated.
consequently, the eviction suit has also become in practice. We do not know.
Whatever, I am only saying
That
that
is being continued
overall,
by the subsequent
overall your lordship may exercise your lordship's equitable jurisdiction. Feel that yes, there is an injustice, but instead of remanding the matter back, that will cause more injustice to all parties than Mulsani. May reduce it proportionately. If your lordship so feels that it is, reduce it proportionately. Because there is no denial by them that the report otherwise, the conclusion is bad. There has to be some challenge.
With the due permission of your ladyship, I would like to answer only one question raised by my senior ladyship.
So enhancement more than 25% is no longer available to you. That has already been taken care of by the full bench.
I'm not
So
convinced.
that is one
I'm
of
not
your
convinced.
grounds. I'm just looking at your
Yes,
grounds.
yes.
This is one of your grounds.
Answering to only one question that has been raised by my learned senior leadership, in page number 21 at the last paragraph, you specifically stated that मकान मालिक कभी भी मकान का मरम्मत नहीं करवाते हैं तथा किराए बढ़ाने का कोई इकरारनामा नहीं हुआ है. नगर पालिका टैक्स 150 रुपए पूरे होल्डिंग का है. That contention we have already taken that
No,
they have without any consideration increased the rent. And in the first line itself, they have stated that it is an asbestos sheet. All these has to be considered. Also, with my statement.
No.
It has been enhanced to 10,000.
10,000 from now in the year 2012 this initial proceeding was initiated. 2013 is the order, so it's almost 12 plus years that the proceeding
12
started.
plus years. In the meantime, there
All these
could have been
development.
in all these developments, and there could be much more enhancement.
Correct.
So some equity between 10.
Request is the lordship may lay down the law for future cases to be covered. This case, instead of remanding because this will not
Because there is no scope for fresh
inquiry. Yes.
inquiry. It cannot be inquired
My
anymore.
only one submission. You should have said that no, it is not 10,000, it is 5,000. I would have agreed. There cannot be. Rent is a component which is not only on the building, it is also on the location, on the area.
Certainly.
So those are various components.
I have at the behest only stated that it is 2500 is also exorbitant since it should be 15.
You should have
So
filed a
you
case for
never went
reduction.
for fixation of parent, did you go?
No.
They have filed an eviction in which I am contesting, your ladyship, in which it has been ordered by the honorable court below that it should be paid till 2500. That proceeding is still ongoing, your ladyship. And bilaterally they have filed another petition for fixation of rent. So far as the subsequent purchasers are concerned, your ladyship, I do not have any tenancy, landlord-tenants
That's
relationship with them. After they have sold off the property,
That's all.
Ah, I think that's true.
WPC number 585 of 2019.
बस कहना है
अपना नाम बताइए.
Pratyush Shonik.
Pratyush.
Shonik.
The senior's appearance is required to be recorded.
Yes.
Then I have to record that he left in between without the name of the court. I'll record that.
I do not have any say in that, your ladyship.
और Mr. Rajendra Krishna. नहीं, देखिए. This petition has been filed for the following relief.
Your ladyship, kindly note that an IE was filed which was allowed, subject to which 2 prayers were added, that is made part of the writ petition in the office.
IA was allowed.
Yes, your ladyship.
What was the additional prayer?
Additional prayer, previously the original order and the appellate order were not challenged, only the revisional order was challenged. By way of IE, we have challenged Annexure 1-2.
What is that IA number?
IE number is
8832.
no, it's
This is that IA.
12114.
1 2.
111. 1211.
That has been allowed, no?
Your ladyship may kindly see the last to last one. Order dated 12/11.
One two double one four.
Yes.
Or Mr. This petition was filed challenging the order dated 5/9/2018, within bracket Annexure 8, passed by learned Divisional Commissioner North Ranakpur Hazaribagh, in House Control Revision number 33 of 2017, whereby division preferred by the petitioner against the order of fixation of fair rent was rejected. However, one IA number 12114 of 2024 was filed seeking amendment of the petition, challenging the
Page number 5.
challenging the order passed by Subdivisional Officer Gildi in case number 1 of 2012 under section 5 of Jharkhand Building within bracket Lease, Rent and Eviction bracket Close Control Act 2002, fixing the fair rent at rupees 10,000 per month. By order dated 9/3/2013, and also challenging the order passed by House Rent Appeal number 3 of 2013, which was dismissed under section 24 of the aforesaid act, which was dismissed by the order dated 19/1/2017. The said introductory application seeking amendment was allowed by order dated
12/11/2024.
12/11/2024, and consequently the order passed by the house rent controller, the appellate order as well as the revision order are under challenge before these proceedings. During the course of argument, the learned counsel for the petitioner has submitted that there has been subsequent developments in connection with the property involved in the present case, and the petitioner has been evicted from the property by the subsequent purchaser from the landlord. And as of now, he is not in possession of the property. To this, the subsequent purchaser, who is also party in the present proceedings, has submitted that the premises has already been demolished. The learned counsel for the petitioner has also submitted that so far as the title eviction suit number 1 of 2004 is concerned, which related to eviction suit filed by the landlord, is still pending.
Yes.
He has submitted that the said suit is on account of default in payment of rent and personal necessity, both.
Yes.
Correct? Is that correct? The learned counsel has, by assailing the impugned orders, has submitted that the order passed by the house rent controller is contrary to the provisions of Section 8 read with Rule 3 framed under the aforesaid Act. We have submitted that the application for fixation of fair rent filed on behalf of the landlord was entertained and an order of inquiry was directed without issuing/serving notice upon the petitioner, and subsequently the inquiry report was received and subsequently inquiry was conducted without notice to the petitioner with regard to fair rent, and the order was also passed by the state authority without giving a copy of the inquiry report, and thereby an opportunity of objecting to the report was also not granted. The Learned Counsel has submitted that the enhancement of rent is from rupees 2,500 per month to rupees 10,000. The Learned Counsel has referred to the provision of Rule 3 to submit that as per the mandate of law, in determining fair rent, the controller is required to take into account various parameters, including the prevailing rate of the rent in the locality for the same or similar accommodation in similar circumstances at any time during the 12 months preceding the date of the order, semicolon, the increased cost of repairs required to be made in the building, semicolon, the amenities, general or special, provided in the building, semicolon, the compound or the open land attached to the building, the type of construction and location of the building, the nature of tenancy, whether it is for residential or business purpose, the municipal tax or corporation tax of the building, any lawful agreement entered into between the landlord and the tenant. He has also submitted that as per Rule 3 itself, the controller is required to fix fair rent after due inquiry and after duly giving notice to the parties concerned and after providing their opportunity of being heard. The Learned Counsel has submitted that there has been gross violation of principles of natural justice inasmuch as the in the aforesaid facts and circumstances as stated above. During the course of argument, it is not in dispute that the property involved in this case is of how much square feet?
18 feet into 53 feet.
How much square feet?
So
18 feet into
53 feet.
53 feet and
954 square.
954 square feet, and is being used for business purpose, that is for running a sweet shop. It is further not in dispute that the property is situated in the prime location.
Yes.
Primarily the grievance of the petitioner is that the condition of the building in which the petitioner is located was also required to be taken into consideration, and merely because in the vicinity certain rate of rent was found was not sufficient, it was to be considered, there was a comparison required to be made with similar circumstances and similar nature of buildings. So far, you want to press this 25%?
I'll not do this.
During the course of argument, the learned counsel has not pressed the ground number D raised in ground as contained in paragraph 2 within bracket D, wherein an objection was raised that the enhancement could not be more than 25%. This happened in view of the fact that the learned counsel for the subsequent purchaser relied upon the judgment passed by this court, the Honorable Patna High Court Ranchi bench reported in 1990 PLJR 61 Patna, and the full bench judgment of this court reported in 2003 bracket close 3 JCR JHR FB, wherein the 1990 PLJR accordingly the said point as raised in paragraph 2 within bracket D does not fall for consideration in this case. The learned counsel has submitted that the gross violation of the provisions of section 8 read with rule 3 has been raised at the threshold before the appellate authority and also before the revisional authority, but this aspect of the matter has not been properly considered. Rather, the revisional authority has recorded that no objection was filed against the inquiry report in the lower court, which was sought to be done before the revisional court, but the learned revisional court has not taken into consideration that the report itself was not provided to the petitioner. The records of the case from the house rent controller was also called for, and has been placed before this court. Thank you. The learned counsel appearing on behalf of the petitioner has submitted that the impugned orders be set aside and the matter be remanded for fresh consideration. The learned counsel appearing on behalf of the respondent landlord has opposed the prayer. Respondent original landlord.
Point number 5.
Respondent number 5 has opposed the prayer and has submitted that the petitioner before the appellate authority and also before the revisional authority did not come up any plea that the it did not come up with any parallel case to show that the report submitted by the circle officer was incorrect. He has also submitted that at the time of hearing before the house rent controller, no objection was raised in connection with the inquiry report, and as of now, the clock cannot be put back in view of the fact that the petitioner has already been evicted by the subsequent purchaser, and as submitted by the subsequent purchaser, the property has already been demolished. He submits that even if the matter is remanded and it is found that there has been violation of the provisions of the Act and the rules, the same will certainly call for a fresh inspection, which is an impossibility as on date. He has also submitted that the foundational fact in connection with the location of the property, the use of the property for commercial purpose, etc., are not denied by the petitioner. The learned counsel appearing on behalf of the respondent number 6 and 7 has also submitted that the petitioner has been evicted and
No, my lord. He himself has left.
has submitted that the petitioner had himself left the premises
In the month of March 2024.
in the month of March
2024.
2024, and as of now, nothing remains on the spot as the building has been demolished. Correct? After hearing the learned, that's all? Anything you want to say? In response, the learned counsel for the petitioner has submitted that the property has the rooftop as asbestos sheet,
which has been admitted by the
which is also
Landlord.
not in dispute.
not in- and also there has not been any repair since the petitioner has gained access to the property.
Okay. After hearing the learned counsel for the parties and upon going through the records of the House Rent Control case number 1 of 2012 as received from the court, from the authority concerned. This court finds that a petition under Section 5 of the Aforesaid Act of 2000 was filed by the respondent number 5 against the petitioner, and on 17/1/2012 the concerned authority expressed that the concerned authority directed for issuance of notice upon the opposite party, upon the present petitioner, fixing the date of hearing as 21/2/2012. However, the case was taken up on 19/3/2012, in which the petitioner remained absent and Circle Officer Giridi was directed to submit a report. Nothing has been mentioned in the order sheet with regard to service of notice upon the petitioner. The Ubhay Paksh is who? Ubhay Paksh, both sides.
Yes, madam. Both.
However, on 16/4/2012, the parties had appeared and the matter was adjourned awaiting the report of the circle officer. After a few dates, the the matter was pending, awaiting the report, and ultimately the report was received as mentioned in order dated 12/2/2013. Thereafter, the matter was directed to be posted on 19/2/2012. On that day, the parties were present and the matter was directed to be posted on 26/2/2023. The parties were heard. It was also recorded that the report of the circle officer was already received and the matter was posted for judgment, for orders. The records of the case do not reveal that at any point of time the report of the circle officer was made available to the parties, to the petitioner. However, while the final order reveals that the respondent landlord relied upon the report of the circle officer. The records further reveal that the petitioner had filed an objection to the petition filed by the respondent seeking fixation of fair rent. And asserted that it was incorrect that the monthly rent of similar accommodation in similar circumstances was rupees 20,000 per month. And has also asserted that the landlord never incurred any cost of repair of the building. No special or general amenities was provided by the landlord, and there was no compound or open land attached to the building. And construction was an old one with a shed of asbestos. The municipal tax for the entire holding was rupees 150 per quarter. And there was no agreement between the parties with regard to enhancement of rent. The house rent controller ultimately had fixed the fair rent. It has taken note of the objection filed by the petitioner in connection with the petition, and also considered the submission that the property is involved in the most important locality in the Giridih town, which was near the secretariat and the civil court, and at the square. And also considered the report of the circle officer that the people in the vicinity were paying rent at rupees 10,000 per month. The authority ultimately enhanced the rent to rupees 10,000 per month. An appeal was filed against the said order, and before the appellate authority, a specific ground was taken that the house rent controller illegally and without any notice to the petitioner and without hearing heard the respondent's lawyer only and directed the circle officer Giridih to submit a report about the market rate of the rent of the premises. And the circle officer Giridih also, without any notice to the petitioner and her knowledge, submitted a report, and the learned collector accepted the report, enhanced the rate to rupees 10,000 per month. The grievance was that the learned collector committed a grave illegality in calling for a report from the Anchal Adhikari in the manner it was done. It was also asserted that it was for the collector to make the inquiry himself, and it could not be inquired into by any other authority, that too behind the back of the tenant. Even the objection was raised in connection with similar accommodation in the vicinity, which was not addressed by the circle officer. The appeal was rejected, while order dated
19/1/2017.
19/1/2017, within bracket annexure 2, in by House Rent Appeal number 3 of 2013, and the appellate authority recorded the submission of both the parties and ultimately rejected the appeal. By citing reasons including the fact that the property is situated in the main locality at the square. The divisional authority, before the divisional authority also, the petitioner thereafter filed revision, and the revision was also dismissed by holding that no objection was filed by the petitioner against the inquiry report, which was sought to be done before the revision authority. This court finds that on the day the House Rent Controller had passed the order for inquiry by the circle officer, there is no recording regarding service of notice to the petitioner, and nobody was appearing on behalf of the petitioner. And ultimately, when the inquiry was conducted by the circle officer, the petitioner was neither noticed by the circle officer nor any opportunity was given to the petitioner to, nor there was any inspection of the premises of the petitioner. Correct? आपका तो कोई inspection नहीं हुआ? Inspection of the premises of the petitioner regarding the available amenities in the premises of the petitioner.
Or the condition of it.
Sorry.
Or the
Or
condition of the
of the
premise.
building. This court also finds that once the report was received by the concerned authority, there is no order to provide a copy of the inquiry report to the parties, much less to the petitioner. And ultimately, when the case was taken up and finally heard, the case was decided on the basis of the recommendation made by the circle officer. This court is of the considered view that the direction to conduct inquiry and the inquiry itself this court is of the considered view that any inquiry in connection with in the matter of fixation of fair rent, when it relates to any authority visiting the premises, was certainly required to be done in presence of the parties, so that each party may have an opportunity to raise their so that even the premises in connection with which the fair rent was to be fixed could have been inspected. This is because of the reason that, as per the provisions of Rule 3, the following factors are required to be taken into consideration. The Rule 3 within bracket Roman 4 also provides that the controller is required to fix fair rent after due inquiry and after duly giving notice to the parties concerned and after providing them the opportunity of being heard. In view of this court is also of the view that once the inquiry report was received by the court, by the authority, it was the duty of the authority to provide a copy of the same to the concerned parties who could have objected to the report, if so advised. But in the present case, the order has been passed on the basis of the inquiry report without providing a copy of the same to the petitioner. This court finds that these aspects of the matter has been ignored by the House Rent Controller and has not been properly considered by the appellate authority as well as the revisional authority. The revisional authority, while recording that the petitioner did not find any objection to the inquiry report, has failed to consider that the inquiry report was not provided to the petitioner, as is apparent from the records received from the House Rent Controller. There is neither any receiving in the order sheet with respect to the report, nor there is any receiving on the inquiry report itself. Having held as aforesaid, this court is of the, and this court having further held that the inquiry in connection with the fixation of house rent was itself not conducted in accordance with law, but on account of subsequent development which has taken place during the pendency of this case, no fresh inquiry can be conducted, as the building does not exist anymore and the petitioner has either himself or has been forcefully evicted from the premises. this court also finds that the petition seeking fixation of parent was filed as back as in the year 2012, and much time has elapsed. The foundational fact in connection with the property that the same is situated at the prime location near the court premises and near the secretariat, and was being utilized for commercial purpose, and the objection which was raised by the petitioner with respect to in the memo of appeal which was filed by the petitioner, the grievance of the petitioner was primarily that the condition of the building in which the petitioner was located was not taken into consideration, in order to balance the equities in view of the fact that no fresh inspection can be directed to be conducted, and the inspection report does not reveal the inspection of the premises of the petitioner. In order to balance the equities between the parties, this court is of the considered view that the कैसे कोई अमाउंट यहाँ से फिक्स कर दें?
So they have given the detail when rent has been
Vicinity. When was he evicted? 2020.
No, 2024. 18/6/2020.
This court is of the view that the learned subdivision officer can still fix the parent by accepting the contentions raised by the petitioner in his objection as correct. Whatever objection you have taken in your petition should be taken as correct. Right? And the petitioner will have an opportunity to object to the report submitted by the circuit officer. Whatever he has stated will be taken as correct and fresh order will be placed. ठीक है? That's all?
टाइम फ्रेम
थोड़ा ऑर्डर में चेंज होगा है ना ठीक है दिस इज व्हाट आई कैन डू बिकॉज आपका प्रेमिसेस तो फ्रेश इंस्पेक्शन नहीं हो सकता सो वॉट एवर यू हैव स्टेटेड इन योर पिटिशन विल बी टेकन एज करेक्ट एंड द फ्रेश ऑर्डर विल बी
टाइम फ्रेम भी फिक्स
द आपके पास रिपोर्ट की कॉपी आ गई है
No.
the petitioner and who will appear both of you who will appear before the authority
since both of us are related
who will
to
appear both of you appear
the dues are there also.
the parties shall appear before the subdivisional officer. I'll fix the date in January at 11 a.m. A copy of the inquiry. आपके पास है copy of the inquiry?
Certified copy.
Certified copy. दे दीजिए उनको. The learned the authority is directed to provide a copy of the inquiry report to the petitioner.
The petitioner or the authorized representative.
नहीं आप खुद ही रहिए.
Because she's an old lady, your ladyship. She is living in Bangalore with her son. The daughter contests the case. If it's possible, the authorized representative will be allowed. Because the respondent number 5 is also an aged person.
You have the certified copy of the inquiry report.
I am giving the photocopy of that. I may be with the party. But
Okay. Or to the authorized representative of the petitioner. After due receipt, within a period of 15 days thereafter, objection may be filed. And you also want to file objection
Lordships, we may be given liberty, Lordship.
to both the parties. Copy देंगे. The liberty with the parties to file their respective objections to the inquiry report, and thereafter the fresh order be passed after granting an opportunity within a period of 1 month thereafter. 15 दिन में अपना ऑब्जेक्शन फाइल कर दीजिए. इनके पास तो रिकॉर्ड ढेर होगा कि आसपास का क्या रेंट है नहीं. They are supposed to keep the record.
Who?
The house rent control.
In our case also, Lordship, representative may be allowed to.
Yes, the representative. Whatever you have stated in your petition will be taken as correct.
Yes, sir.
बाकी आप ऑब्जेक्शन करें. यहाँ से नहीं फिक्स कर सकते थे 26 में.
This-
ऑर्डर गलत हो जाएगा.
Only this could have been done, Your Lordship. It can only be remanded for fresh consideration.
ऑर्डर थोड़ा चेंज होगा. That's it.
Always.
हम कर देते हैं यही से लेकिन वो ऑर्डर ही गलत है. नहीं कर सकते.
From 10 days for judgment item 1, the rupee 2796 of 2001.
$4 lakhs per head का ऑर्डर. 4 lakh. And also to the legal years if anybody has expired.
For final disclosure, item 2, the rupees 4039 of 2005, along with item 3.
First case is regarding the minimum wages act. The principal amount is 6,800 and press it. 6,000 rupees. 6,800 and then 10 times compensation and then Rahat Rashi altogether 1 lakh. Amount involved is 1 lakh. The first case, total amount. Principal amount, the minimum wages act, the difference is 6,800 because he has worked only for 15 months on part-time basis. This is with WPC number 4039. 4039. He was working as a cleaner in the club, Telco club. He used to wash the utensils for, as per our pleading, for only for 4 hours in the
hours से नहीं determine होगा ना
नहीं वो 20
per day के हिसाब से चलेगा
section 20 बोलता है कि adult he should work for 9 hours and he was working, that has not been replied by them.
that doesn't make any difference
So principal amount is 6,000. Just reading the order immediately.
so you want to withdraw this case principal amount is 6,000 why are you fighting 6,000 telco club can't get
नहीं principal amount हम देने को तैयार हैं
क्या चीज और क्या बच गया
जी हम देने को तैयार हैं
क्या बच गया और क्या है प्रिंसिपल अमाउंट के अलावा
प्रिंसिपल अमाउंट के अलावा 10 compensation तो राहत की राशि है many things in the petition also only he has stated that he is working it and neither he has stated that for how many hours. We have made pleading that for it was his extra work and he has nowhere pleaded that yes I was working for this month, no evidence, no salary slip, nothing.
what is your ground you tell us
Petition.
what is your ground for telling that he was working for 4 hours
Yes, he was working part-time, working the washing the utensils
part time
part-time for 4 hours.
4 hours
4 hours.
okay
Section Rule 24A says for adult it should be 9 hours.
rule 24
A.
small a capital A
Small A.
so they should work for 9 hours
9 hours. So in the petition also he has pleaded what how many hours he was working, nor he has produced any evidence that yes this is the salary or any evidence regarding this fact.
okay regarding the length of hours of work.
So
what was your case before the court what was your case
yes, my
before the
case,
court यहाँ read से मत बताइए
Yes.
impugn order से बताइए
I can notice I was never given, my case is that I was never given opportunity. His limitation was condoned without hearing me. On that ground, everything has been dealt. I am reading the order. That is annexure 3/1. छोटा सा ऑर्डर क्योंकि बहुत सारा चीज कवर अप हो जाएगा. They file amendment, limitation condoned. We filed petition for ex parte order, that was rejected. Then we filed appeal also, that was also not entertained.
those orders are not under challenge
नहीं.
you have only challenged the final order right
Quashing the order, one more order of the appellate order.
yes
हाँ,
yes
that
so
was not.
those orders that it was those specific orders are not under challenge
16/7/4 का भी हम किए हैं. Whereby petition for recall of order dated 4/6/2004 was dismissed.
4/6 where is that order 4/6/2004
4/6/2004 3/1.
3/1 is the final order
हाँ, final order.
where is 4/6 you say that order refusing to recall has been challenged where is that where is that order
I have challenged the order 4/6/24 only and 13/6/2005
appellate order
for question. So first, just I'm reading 4/6/24. Everything will be clear. 4/6/24.
you read the appellate order first
105
Yes.
मैसेज टेल्को क्लब जमशेदपुर अपीलकर्ता द्वारा सहायक श्रम आयुक्त सह प्राधिकरण न्यूनतम मजदूरी अधिनियम 1600 जमशेदपुर के द्वारा वाद संख्या इतना में पारित आदेश 4/6/2004 के विरुद्ध अपील दायर किया गया है। दायर अपील की प्रति कामगार को प्रेषित करते हुए दोनों पक्षों को अपनी स्वीकार किया जाए अथवा नहीं के बिंदु पर सुनवाई हेतु 21/4/2005 निर्धारित की गई। निर्धारित तिथि को दोनों पक्ष उपस्थित हुए तथा दोनों पक्षों ने अपना अपना पक्ष रखा। अपीलकर्ता द्वारा कहा गया है कि प्रतिवादी नंबर 1 द्वारा न्यूनतम मजदूरी वाद संख्या 279/2002 निबंधित किया गया और अपीलकर्ता को सुने बिना कालावधित अवधि को क्षांत किया गया। उनका यह भी कहना है कि उन्हें नोटिस तामीला कराया गया और एक तरफा कार्रवाई का उनके विरुद्ध निर्देश जारी किया गया जिसके कारण उन्हें न्याय नहीं मिला। उनका यह भी कहना है कि 4/6/2004 को भेजा गया है जो अपीलकर्ता को 10/8/2004 को प्राप्त हुआ। प्रतिवादी का कहना है कि अपीलकर्ता अपने अपीलवाद की खंडिका 10C में अनुरोध किया है कि कालावधि अवधि को शांत किया जाए जिससे स्पष्ट है कि अपीलकर्ता द्वारा निर्धारित समय सीमा के अंदर अपील नहीं किया गया। उनके यह भी कहना है कि न्यूनतम मजदूरी अधिनियम की धारा 20 की धारा 6(1) तथा 6(क) की ओर ध्यान आकृष्ट करते हुए अनुरोध किया गया है कि इस अपील को स्वीकार नहीं किया जाए। दोनों पक्षों को सुनने के पश्चात यह प्रश्न उठता है कि क्या यह अपील वाद न्यूनतम मजदूरी के अधिनियम के प्रावधान के अनुसार निर्धारित समय सीमा के अंदर दायर किया गया है। इस अपीलवाद के स्वीकृत करने अथवा स्वीकृत करने के प्रश्न पर स्टेट अमेंडमेंट बिहार एक्ट 5 ऑफ 1983 पर गौर करना आवश्यक है जिसके द्वारा संशोधित धारा अंतर स्थापित की गई है। 6. उप धारा 1 के अधीन के नियुक्ति किसी प्राधिकार द्वारा उप धारा 3 के अधीन दिए गए निर्देश से व्यथित कोई नियोजक या कर्मकार इस अधिनियम के अंतर्गत नियुक्त नहीं। कोई निरीक्षक उप धारा 2 के अधीन आवेदन किए जाने पर निर्देश के तारीख 30 दिनों के भीतर ऐसी रीति से और ऐसे प्राधिकारी के पास अपील कर सकेगा जिसे राज्य सरकार अधिसूचना द्वारा इस निर्दिष्ट करे और यह प्राधिकारी अपील की सुनवाई करने के बाद उस निर्देश को जिसके विरुद्ध अपील की गई है समुचित उत्तरित या परिवर्तित कर सकेगा तथा उस प्राधिकारी द्वारा दिए गए आदेश के विरुद्ध पुनः कोई अपील किसी न्यायालय में नहीं होगी। 6. यदि इस बात का समाधान हो जाए कि आवेदक पर्याप्त कारण से धारा 6 में निर्दिष्ट
ऑर्डर इसमें करना ही तो।
हाँ
तो part by limitation.
but I have given the reason when I received and when I have
So that has been also considered.
I have stated that
ये अपील लास्ट पैराग्राफ पढ़िए इसका।
यह अपीलवाद दिनांक 11/10/2004 को अपीलीय प्राधिकार के न्यायालय में उपस्थित किया गया जो अधिनियम की धारा 20 और 6 का निर्धारित समय सीमा के अंदर नहीं है। यदि अपीलकर्ता की अपील की कंडिका 11 को मान भी लिया जाए तो निचले न्यायालय का आदेश दिनांक 4/6/2004 और दिनांक 17/7/2004 दिनांक 29/4/2004 को भेजा गया। उन्हें दिनांक 10/8/2004 को मिला फिर भी प्रवादित समय सीमा के अंदर दाखिल नहीं किया गया चूंकि अधिनियम की धारा 20 के अनुसार 30 दिनों के अंदर भीतर और यही प्रावधान 20(6) का अतिरिक्त 30 दिनों के भीतर लेकिन उसके बाद नहीं लागू माना जाएगा।
आपका तो उसके बियॉन्ड भी हो गया ना।
बट आई हैव गिवन द डेट इन माय पिटीशन।
ये तो आप ही करना है। दिस इज योर ऑन द बेसिस ऑफ योर पिटीशन दिस ऑर्डर हैज बीन पास्ड। आपको क्या बोलना है?
So far as this case is concerned, if I will see the first order, so many times they have taken time and they have completely neglected to contest the case, and after passing on the order they are claiming that opportunity was not given to me, so please recall that order. There is no provision of recall of order by administrative authority, so there is no merit in this matter.
This is which section are they talking about? Minimum wages?
24A. Rule 24A.
She is saying about rule, my lord.
Rule 24A.
Night shift, no, we are not bothered about it. About the delay, ये कौन सा है section?
ये
Delay का
DA
कौन सा
20 का सब सेक्शन 6 है, इसमें नहीं हो बिहार अमेंडमेंट में है my lords. वो लिमिटेड है 30 दिन के बाद एंड नेक्स्ट 30 डे, उससे ज्यादा उनको पावर ही नहीं है करना।
पावर ही नहीं है।
जी वही लिखा हुआ है।
WPL number 4039 of 2005.
एक इसमें दो केस है।
एक पहले इसको कर देते हैं।
So at that time also I have made this submission that principal amount I was always ready. इसमें आया भी है कि वो लोग
ये सर बार्गेन नहीं होता ना मैडम?
but कॉम्पनसेशन
26 में हम लोग आपका परवर्सिटी
एक बार खाली इसका ऑर्डर देख लिया जाए, ये क्या क्या अमाउंट कैसे दिए हैं, वेदर इट इज एप्लीकेबल, वेदर इट कैन बी और नॉट, और लॉ क्या करता है।
नहीं, वो तो नहीं देख सकते ना, जब आपका पिटीशन ही टाइम बार्ड हो गया तो क्या ही देख सकते हैं। जो एपेलेट अथॉरिटी नहीं देख सकता है वो हम लोग रिट में कैसे देखेंगे?
नहीं, ये खाली अमाउंट ये जो दिया गया है, एक ये है इसमें 10 टाइम कॉम्पनसेशन, ये किस लॉ के अंदर दिया गया है, और फिर सहायक बोलते हैं, एक बार खाली हमको अमाउंट पढ़ दे रहे हैं कैसे दिया गया है, उसको खाली बस कंसीडर
नहीं कर सकते ना।
तो ये किस
When
लॉ में
appeal
ये
has
दिए हैं?
become barred by limitation, we cannot
हाँ,
enter
नहीं,
into the merit.
हम खाली क्या कहना चाह रहे हैं कि ये अमाउंट कोई प्रोविजन के अंतर्गत,
नहीं
प्रोविजन
करेंगे।
बोलता है कि मैक्सिमम 10 टाइम्स कॉम्पनसेशन, मैक्सिमम टू द नेचर ऑफ द केस। तो 10 टाइम भी अगर किया जाए तो मैडम वो एक बार खाली दिखा देना चाह रहे हैं कि वो 63 आएगा, फिर वो एक और कोई सहायक राशि की है जो कि इसमें नहीं कहता है, हम खाली उसी पॉइंट पर हैं। एक बार इसको खाली देखा जाए, नहीं ऑर्डर में खाली ऑर्डर एक बार देख लिया जाए, फाइनल ऑर्डर एक बार खाली देख लिया जाए, क्योंकि इनका पिटीशन में ये क्या मांगे हैं वो भी एक बार देखना है। ये सिर्फ मांगे हैं एक बार हम वो दिखा दे रहे हैं, और फिर किस लॉ के अंतर्गत दिया गया हम खाली वो दिखा रहे हैं, बस 2 चीजें दिखा दे रहे हैं बिफोर
12,000 इतना ही तो था आपका।
हाँ, ये हम बस आ रहे हो पिटीशन में आ रहे हैं, मेन पिटीशन जो इनका है।
नहीं, उनका पिटीशन नहीं, आप ऑर्डर पढ़िए ना मैडम। टाइम बार्ड, when the appellate order is expressly barred by limitation, there is no scope for this court to enter into the merits of the case. What do you have to say to this?
तो ये 10 इसमें लॉ जो कहता है कि मैक्सिमम 10 टाइम्स मैक्सिमम, उसके बाद कोई राशि नहीं है, तो ये भी पिटीशन में यही दिए हैं, लेकिन कोर्ट उसको आउटसाइड द जुरिसडिक्शन हैज गिवन द अमाउंट, हम खाली उतना पर हम आ रहे हैं। ये एक बार ये खाली अमाउंट एक बार देखा जाए, ये अपने पिटीशन में लिखे हैं 6,700।
पिटीशन का बात छोड़ दीजिए
हाँ,
आप,
ठीक है,
आप हमको ऑर्डर बताइए।
हाँ ऑर्डर हम
ऑर्डर विदाउट जुरिसडिक्शन हो गया है।
वो अमाउंट तो मैक्सिमम 10 टाइम्स के बाद तो कोई अमाउंट नहीं हो सकता है, तो ये कैसे कर दिए, 6,700 है तो उसका मैक्सिमम 10 टाइम्स है।
पेज
फिर
46
सहायक
देख लिया जाए माय लॉर्ड, उसको अमेंडमेंट करके 12,000 चेंज किया गया था, दैट वाज परमिटेड। पेज 46 देख लीजिए।
नहीं, इतना नहीं सोच सकते।
Amendment
इतना छोटा अमाउंट के लिए आप लोग मिनिमम वेजेस भी नहीं देते हैं, मतलब
मिनिमम वेजेस तो हमेशा देने को तैयार है,
देने को तैयार है, देते नहीं है ना।
अब 25,000 ऑर्डर शीट में आया भी है, कोर्ट का ऑर्डर शीट में हम 25,000 रुपए उस समय जब ये केस टेकअप हुआ था तो हम अपने इंस्ट्रक्शन लेके बोले थे कि आप
तो बाकी पैसा दे दीजिए
मैडम, वो थोड़ा ज्यादा हो जा रहा है, वो थोड़ा 10 टाइम्स मैक्सिमम है, वो सारा वो 12,000 बढ़ा के 6,000 को 12,000 बढ़ा दिया गया है, खाली उसको थोड़ा कंसीडर
नहीं कर सकते ना कंसीडर। टाइम बाद पिटीशन पे हम क्या ही कंसीडर
अमाउंट पर हम बोल रहे हैं मैडम,
नहीं कर सकते ना।
सिर्फ
amount पर।
15 महीना वो काम किया है।
मैडम, आप लॉ नहीं समझ रहे हैं या समझना नहीं चाहते हैं। A petition which has been rejected as time barred, how this court will enter into the merits of the case? Under what provision of law? कुछ समझाइए, लॉ समझाइए हमको।
वन वो
विदाउट जुरिसडिक्शन होगा तो नलिटी कर सकते हैं पूरा ऑर्डर।
एक और चीज है, एक और चीज है जो स्टैट्यूट बोलता है कि जिस दिन से ड्यू है मिनिमम वेजेस एक्ट, उसके 6 मंथ्स के अंदर आपको प्रेफर करना है एप्लीकेशन। दैट हैज आल्सो बीन डन आफ्टर 6
लिमिटेशन कंट्रोल हो गया था ना। WPC number 4039 of 2005. This writ petition has been filed for the following relief. The order passed by the authority under Minimum Wages Act, that is respondent number 2,
एक और करेक्शन
and also the order passed by the
1,03,000 बोले हैं, फिर उसको 1,16,000 कैसे बोले, खाली पर वो देख लिया है लास्ट लाइन ऑर्डर का, मेन ऑर्डर का
क्या बोल रहे हैं
यहाँ पर। अतः ऊपर नामित सभी प्रति की आदेश देता हूँ कि मूल बकाये की 8 गुनी राशि, मूल बकाये की 8 गुनी राशि 1,03,000।
1,03,000 है ना आपका,
10-12,000 ओरिजिनल है मैडम,
तो 12,000 ओरिजिनल है,
जोड़िएगा तो हो जाएगा।
जोड़ के हो जाएगा इतना। Honorable Learned Counsel appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petition seeking confirmation of delay was allowed in the absence of the petitioner. And there is a mismatch in the order passed by the Assistant Labour Commissioner from Authority under the Minimum Wages Act.
Ladyship, my submission regarding 24A may be recorded.
She has submitted that on one hand, the 8 times amount has been mentioned as rupees 1,03,181.92, but in the final portion of the order itself, there is a direction to pay rupees 1,16,079.66. She has further submitted that as per the provisions of section 24,
Rule 24A.
Rule 24 capital A of Minimum Wages Act, of Minimum Wages Central Rules,
Page, if the book is same, page 67.
where there is a provision as to how the period of working hours is to be calculated. She submits that the workman in the present case was working only for 4 hours,
Part time.
and accordingly he was a part-time worker. The learned counsel submits that the provision of law has not been properly considered. The appeal against the said order has also been dismissed. The original order is contained at Annexure 3/1, and the appellate order rejecting the appeal is contained at Annexure 5. The learned counsel, that's all. Kuch chut gaya? The learned counsel appearing on behalf of the respondents has submitted that in spite of service of notice and repeated opportunities, the petitioner was not cooperating with the proceedings, and the delay was condoned.
Yes, one judgment is there.
He has also submitted that the appellate authority has
On this
dismissed the appeal on ground of limitation by observing that the power to condone delay beyond 60 days was not available.
one judgment that
The learned counsel has also submitted that once the appeal was dismissed on the point of limitation, there is no question of entering into the merits of the case. He has submitted that the prescribed period of limitation under Bihar rules,
we have
under Bihar rules is 30 days.
बिहार अमेंडमेंट एक्ट है माइनर 26 सेक्शन इंसर्ट किया गया बिहार का जो ये मिनिमम वेजेज एक्ट है माइनर
हाँ,
that has been amended by state of Bihar and in that section 20 subsection 6 there is provision.
there is a provision for filing appeal within 30 days, and delay is condonable only up to 30
Further
days
30
thereafter.
days, yes.
30 days thereafter,
Right.
and not beyond that.
Yes. 6 का मतलब 6A उसको आप बोल सकते हैं After 6A has been inserted by state
After
of
hearing the learned counsel appearing on behalf of the parties
एक सेकेंड
and considering the facts and circumstances of this case,
एक इसमें
this court finds that the authority under the Minimum Wages Act has determined the amount payable to be rupees 1,16,079.66. The principal amount was rupees 12,897.74.
इनिशियल was 6
And- यही है ना 12,897.
एनहांसमेंट के बाद
Right.
इसमें खाली ये जजमेंट को रेफर
12
कर दिया जाए
897,74 and the 8 times compensation was quantified as rupees 1,03, 181.92 and when added it came to rupees 1,16,079.66. ये ऐड करने से आता है exactly? This court finds that the petitioner had a filed appeal before the appellate authority and the appellate authority has refused to condone the delay in view of the fact that the appeal itself was filed beyond the permissible period of condonation of delay. This court is of the considered view that once the appeal was filed, once the appeal was dismissed on such ground of delay, there is no scope for entering into the merits of the case. Under Article 226 of the Constitution of
Can I
India.
intervene?
Accordingly, this litigation is hereby dismissed.
मैडम इसको थोड़ा रेफर करें
ऐसे नहीं रेफर कर सकते ना मैडम, आर्गुमेंट के समय तो आप दिए
आप
नहीं।
ब्रॉड
आप लाए होंगे बट यू नेवर साइटेड।
खाली रेफर कर दिया
ऐसे नहीं रेफर कर सकते मैडम, इट इज नॉट लाइक दिस।
Before passing the order, I tried to take a lead to.
ऐसे
इसमें एक बार खाली इसको देख लिया जाए।
क्या है ये?
इसमें बोलता है कि एक बार
क्या बोलता है बताइए, ऐसे नहीं
हाँ,
लेंगे।
इसमें बोलता है कि if he is out of service, section 20 will not be applicable for minimum wage act. If he is not in service.
That also we cannot. To the next.
This has been dealt here.
दोनों
एक दूसरा दिखाइए, दूसरा में क्या बोलना है?
दूसरा में उसमें है कि रीइंस्टेटमेंट बकाया राशि के साथ बकाया राशि तो रीइंस्टेटमेंट का ही वाज ओनली फॉर 15 months on part time basis so this question arises whether he can be reinstated or not if he was in only for part time service for 15 months nowhere it has come that he was working for the whole day also no pleading nothing.
Where is the order? This is under Shops and Establishment Act.
So there are many questions whether it is an establishment club which is registered under cooperative societies.
Club is not an establishment.
Establishment में बोलता है कि जो business or trade, it is not for business or trade. First thing is that there establishment भी का बहुत broader meaning है. We will have to see that whether it comes under, as per my understanding, the places where we eat or the places, but one place it says business or trade. So a club is not for business, it is just for entertainment of the members. The membership is being given by the members of the management
Entry
company.
of outsiders is prohibited.
Member
completely.
हाँ अभी तो इंस्ट्रक्शन ये बोले कि जो
अभी
मेंबर होते हैं
records.
हाँ मेंबर जो होते हैं वही कर सकते हैं वहाँ जाकर खा सकते हैं जो मेंबर होते हैं एंड दे आर वेरी फ्यू मेंबर outsider mostly they are employee of the management Tata Motors. So the establishment it comes under that or not. Second thing he has worked as a
Do you have a
part-time.
liquor license?
जी
Do you have a liquor license?
liquor I don't know.
होगा ही ना, क्लब है, बिना लाइसेंस के तो नहीं हो सकता है।
मैडम हम नहीं जानते वो कैसे बोल रहे कोर्ट के सामने for this I have to ask them. I don't know. Really I don't know. taken.
It's a club. You
Club.
see, it's a club.
Club,
All
it's a
these
club.
licenses are required.
Depends, सब क्लब में नहीं होता है. जैसे
Okay,
यहाँ
come
कुछ
to the
clubs हैं.
finding. Let us see what is the finding. We will not go by the general
And
understanding
एक
of
सबसे
Second
important
case,
चीज है
one of the
मैडम,
famous
सबसे
is
important चीज है
yesterday.
मैडम, I'm not completed. Second सबसे मेरा पूरी समझ जर्मन नहीं हुआ, इतना हड़बड़ी में हो गया. मैडम सबसे important चीज है कि he has worked only as a part time for 15 months. So question is that if he is a part time, where the question of reinstatement comes, that has to be seen.
part time for 15 months. Is there any finding to that effect?
Yes, that is there.
Where is that finding?
That
There is
is
a directive for reinstatement.
जी, reinstatement बकाया राशि के साथ
बताइए कहाँ है?
है वो. इसमें उनका एप्लीकेशन में भी है. एप्लीकेशन इज
आप ऑर्डर पढ़िए ना, इंक्लूड ऑर्डर में क्या है पढ़िए. आपको बार बार मौका दिया लेकिन आप अपीयर नहीं होते, ऐसा है क्या इसमें? यू डिड नॉट अपीयर.
नहीं अपीयर किए थे.
तो ये गलत लिख दिए हैं क्या? दे हैव रॉन्गली रिटन. आप पढ़िए, इंक्लूड ऑर्डर पढ़िए, एनेक्स 6 दोनों पक्षों को सुना. आगे क्या लिखा?
दिनांक 6 इलेक्शन 6 में
एक और ऑर्डर है ना, 2 ऑर्डर है ना इसमें.
इलेक्शन 6 है. आदेश दिनांक 20/1/2005.
Where is the main order?
मेन ऑर्डर. मेन ऑर्डर बिफोर दैट.
4/6/2004.
जी.
Where is the main order? पढ़िए.
शुरू से पढ़.
पेज नंबर 23 में भी है. पेज नंबर 23 में है. पेज नंबर 23 देखिए. आप आपका भी साथ.
मोहम्मद अख्तर वल मोहम्मद रोड नंबर 6 झारखंड कान प्रतिष्ठान अधिनियम घटना की धारा 26 के अंतर्गत अपने बकाया वेतन के भुगतान एवं कार्यमुक्ति के विरुद्ध दावा पत्र दायर किया, जिसमें उन्होंने बताया कि प्रतिवादी के यहाँ दिनांक 1/5/2001 से 30/6/2002 एप्लीकेशन में भी है, उनका एप्लीकेशन रिकॉर्ड पर है, उसमें भी है 1/1/2001 से 30/6/2002 तक 1200 रुपये मासिक वेतन पर किचन हेल्पर का काम करते थे. प्रतिवादी से सरकारी दर से मजदूरी की मांग किए जाने के कारण 1/7/2002 से बिना कोई कारण बताए कार्य करने में नियोजक द्वारा रोका गया है. उनके द्वारा बकाया मजदूरी का भुगतान तथा पुनर्स्थापन की मांग की गई है. दावा पत्र पंजीकृत किया गया. वादी आवेदक मोहम्मद अख्तर से प्राप्त दावा पत्र की एक प्रति प्रतिवादी नियोजक को भेजी गई. उनके जवाब दाखिल करने हेतु तिथि 30/5/2006 निर्धारित की गई. निर्धारित तिथि पर नियोजक न तो उपस्थित हुए, न ही कोई जवाब दाखिल किए. न्यायालय द्वारा कई तिथियां निर्धारित की गई, किंतु नियोजक द्वारा कोई जवाब दाखिल नहीं किया गया. निर्धारित तिथियों पर नियोजक पक्ष द्वारा जवाब नहीं दाखिल करने पर न्यायालय द्वारा नियोजक को जवाब देने हेतु पत्र भेजा गया. दिनांक 26/10 को उपस्थित होकर अपना जवाब प्रस्तुत करे, किंतु जवाब उसके बाद 11/11/2003 को सुनवाई हेतु बार तिथि निर्धारित पश्चात उपस्थित होकर जवाब नहीं देने पर वादी पक्ष द्वारा जोरदार एवं कड़ी उपस्थिति जताई आपत्ति जताई अनुरोध किया गया कि एक पक्षी कार्रवाई की जाए. वादी के अनुरोध के अगली तिथि 1/12/2003 निर्धारित करते हुए प्रतिवादी को आदेश दिया गया कि तिथि पर जवाब दे, एक पक्षी कार्रवाई की जाएगी. इसकी सूचना प्रतिवादी को दी गई. प्रतिवादी द्वारा उक्त तिथि को भी अपना जवाब 10 पश्चात एक पक्षी कार्य करते हुए वादी को अपना साक्ष प्रस्तुत करने हेतु 7/1/2004 को आदेश दिया गया. उसकी सूचना प्रतिवादी को निबंधित हुई. उक्त तिथि को प्रतिवादी द्वारा न कोई जवाब दिया गया, न कार्रवाई. दिनांक 7/1/4 को वादी अपने गवाह उपस्थित होकर न्यायालय में दर्ज करा, जिसमें बताया कि नियोजक खेलको क्लब में किचन हेल्पर के पद पर कार्यरत हैं. 1200 रुपये का मासिक वेतन मिलता था. वे न्यूनतम वेतन की मांग करते थे. इसी बीच 15/4/2002 को क्लब का भी श्रम विभाग के द्वारा निरीक्षण किया गया था. उस समय नियोजित दल कुछ समय के लिए बाहर हटा दिया गया. इसमें विभागीय पदाधिकारियों के समक्ष न्यूनतम वेतन तथा सर्विस रिकॉर्ड एवं की मांग. उनके द्वारा इस व्यवहार से नियोजक खिन्न होकर 1/7/2002 से उन्हें मौखिक रूप से बताया कि 1200 रुपये में मौखिक वेतन पे काम करना है मासिक। आवेदक द्वारा वे गरीब परिवार के व्यक्ति हैं जिसका भरण पोषण 1200 रुपये में नहीं हो सकता। नियोजक प्रति प्रतिष्ठान में कार्य में पुनः योगदान करने नहीं दिया गया। मैं अपने करने से नियोजक को बार बार कहा किंतु उनके द्वारा भुगतान नहीं किए जाने पर श्रम आयोजक जमशेदपुर के यहाँ दिए गए शिकायत एवं निर्धारित की गई किंतु नियोजक ने जांच एवं वार्ता में तो भाग लिया, नहीं कोई अपना जवाब दिया। वादी आवेदक द्वारा अपने साक्ष्य के क्रम में सहायक भविष्य निधि आयोग जमशेदपुर की आदि की प्रति दाखिल की गई। स्पष्ट किया है कि सो की अवधि में नियोजक टेल्को क्लब में कार्य किया है। उनके कर्मचारी मानते हुए उनके पीएफ कॉलोनी कटौती जमा करने का आदेश दिया गया। टेल्को द्वारा इस आदेश के अनुपालन में पीएफ जमा किया गया, इस पर कार्य करने में उन्होंने अपना दावा प्रस्तुत। आवेदक नियोजक द्वारा न कोई कार्य की सूचना दी गई, न की जांच की गई, न ही वहाँ का नोटिस दिया गया। बिना किसी कारण के उन्होंने रोकने का कार्य किया।
क्या बचा है इसमें? What is the illegality in this?
नहीं, reinstatement he was on part time.
पार्ट टाइम कहाँ लिखे थे? 4 घंटा काम करते हैं।
हाँ लिखे हैं।
कहाँ? 4 hours per day।
हाँ उस पिटीशन में किया है।
किधर? किचन हेल्पर का काम करते थे। कहाँ लिखा है कि 4 घंटा काम करते थे?
हाँ मैडम, शोकॉज जो फाइल हुआ उसमें भी लिखा है।
शोकॉज से नहीं आती, किसी ऑर्डर से पढ़िए ना। आपने तो शोकॉज फाइल ही नहीं किया। मिनिमम फाइल हो शोकॉज।
मिनिमम वेजेस एक्ट में शोकॉज फाइल का
उससे क्या लेना देना है?
ये फाइल हुआ है।
Which is a separate proceeding.
Annexure 3
और 4 घंटा करते थे, इससे क्या ही लेना देना है?
ये दिन में दूसरे जगह काम करते थे, मेरे यहाँ फिर पार्ट टाइम आकर बर्तन शाम का धोते थे।
Annexure 3 क्या है?
ये है हम्बल पिटीशन ऑन बिहाफ ऑफ द अपोजिट पार्टी अभी
ये तो आप रिकॉल के लिए फाइल किया।
एक महीना के अंदर
हाँ।
फाइल हो गया।
इसमें हम ये आया है फिर दिखा रहे हैं। रिव्यू पिटीशन फाइल किए हैं उसके बाद नेक्स्ट
रिव्यू मेंटेनेबल है? रिव्यू का पावर ही नहीं है तो रिव्यू कैसे मेंटेनेबल है?
ओरिजिनल केस रिस्टोर करने के लिए फाइल किए।
डीएफडी नहीं है, केस हैज बीन डिसाइडेड ऑन मेरिट, इसलिए ओरिजिनल केस तो वैसे ही नहीं रिस्टोर हो सकता। सही।
और फिर हम फाइल किए हैं मिनिमम वेजेस एक्ट में शोकॉज फाइल किए हैं जिसमें लिखे हैं।
इससे तो मतलब नहीं है। मिनिमम वेजेस इज अ सेपरेट प्रोसीडिंग, दिस इज अ
But
सेपरेट।
whether question arises whether if he was on ad hoc basis whether he can be reinstated or not.
ad hoc
Ad
बोल
hoc नहीं part time.
पार्ट टाइम भी कहाँ लिखा है? फ्रॉम वेयर डू यू से पार्ट टाइम? यू नेवर फाइल योर शो कॉज।
इनका पिटीशन देखा जाए एक बार, इनका पिटीशन तो देखा जाए कि व्हाट क्लियर ही हैज मेड। इनका पिटीशन एक बार देखिए जी। ये है एनेक्चर 1।
पढ़िए, इसमें लिखे हैं हम पार्ट टाइम काम करते हैं।
ये बोलते किचन हेल्पर के रूप में हम काम करते थे। कहीं भी ये एक नॉट अ सिंगल चिट ऑफ एविडेंस ही हैज प्रोड्यूस्ड दैट ही वाज वर्किंग एज अ फुल टाइम वर्कर एंड गेटिंग दिस मच।
क्या ही एविडेंस प्रोड्यूस करेंगे? ही वाज एडमिटेडली वर्किंग।
कहीं कोई सैलरी स्लिप तो ये लगाया नहीं कि हमको हर महीना ही हमको इतना मिलता था। ये जब जिस दिन काम करते थे उस दिन हमको पैसा मिलता था। अगर ये संडे नहीं आ रहा है तो संडे का पैसा नहीं
रिकॉर्ड
मिलता
पे
था।
नहीं है, उसको मत बताइए। आपने शो कॉज क्यों नहीं फाइल किया? You never filed a show cause in spite of repeated opportunities, and he has deposed that because he was asking for minimum wages, you dismissed him. That was the reason.
Dismissed,
discontinued, terminated,
Discontinued.
whatever. 15 months काम किया ना?
discontinue।
Yes, he
तो
worked for
part-
15 days, 15 months, जितना period वो काम किए,
जी।
ठीक है? Under that provision, he could not have been reinstated.
Reinstated मैडम तो इनका परमानेंट एम्प्लॉयमेंट तो नहीं था
तो
ना।
कहाँ से आप
Reinstated
कहाँ से बोल रहे हैं? आप तो शो कॉज भी नहीं फाइल किए।
तो
In spite of so many opportunities, he has narrated so many opportunities to you. आपको कोई मतलब ही नहीं, आप तो क्लब है ना, वही रहिए। और क्लब में तो शाम को 4 ही घंटा काम होता है, दिन में थोड़ी काम होता है। लेकिन परमानेंट एम्प्लॉइज रहते हैं क्लब में।
परमानेंट एम्प्लॉयज लेकिन मैडम बहुत कम परमानेंट एम्प्लॉयज होते हैं वहाँ
हम लोग कॉमन सेंस कॉमन
पूछे
नॉलेज
हैं।
से नहीं चल सकते
हाँ
ना हम लोग।
पूछे हैं और क्लब 24 आवर्स खुला भी नहीं रहता है, सिर्फ दिन में लंच हम पता किए कि कितना
उससे क्या
घंटा-
मतलब है? We are seeing the records. You come to the records.
जी तो वेदर
ये shops and establishment है।
shops and establishment whether it is establishment or not.
ये यहाँ कैसे डिसाइड होगा whether it is an establishment or not? क्लब का प्रिंसिपल ऑफ म्यूचुअलिटी पर आप जाइएगा। That requires evidence.
And whether he is now he is superannuated or
We
what,
do not know.
yes he might be superannuated but we should
Might
take
have
this-
been. We will say that that if he has attained the age of superannuation, then it will be restricted till the age of superannuation. His back wages.
एक चीज और establishment एक बार देख लिया है। Just I was also trying to search out this whether it comes under establishment or not.
क्या बोल रहे हैं आप? क्या एज था इनका? What was his age?
My lord, that is nothing clear, my lords. Nothing is mentioned here, and secondly, I tried to contact him also, I could not contact him, my lord. But the way he was working since 2001, my lords, he must be within the service age.
वो तो कहाँ भी जा सकता है, कहीं और भी काम कर सकते हैं हेल्पर से कितना एज था, that is not on the record, it nothing can be said.
He had worked for only 15 months.
Yes. Therefore, I was saying, my lords, under the similar circumstance under ID Act 25F is there, here 26(1) is there. That has not been complied. So I was only saying, my lords, that the BSNL judgment which my lords were saying on that very day, my lords, that judgment will be applicable here. Some compensation should be given to him.
Compensation.
हाँ,
इसमें कैसे compensation?
तो इसमें नहीं compensation तो restatement होगा, मैडम
You
ये
see, it's a case where he has been victimized
my lords,
for asking for wages.
my lords.
तो ये BSNL वाले वो one time shake hand golden second type से नहीं हो सकता
नहीं
है।
होगा, वही तो हम बोल रहे हैं। ये केस में he has been victimized only because he was asking for minimum.
For minimum,
और जो भी
whatever
बोल-
wages, because सरकारी दर से मजदूरी मांग किए
हाँ।
जा रहे हैं, this is all established.
वो भी
Because
है कि
ना तो क्रॉस एग्जामिन किए हैं, ना
हाँ।
अपना शोकॉज फाइल किए हैं, ना
नहीं।
कोई एक्सप्लेनेशन
और केस होते ही जब सूचना के 1 महीना के अंदर
Like-
पिटीशन फाइल
ये एक बार जजमेंट देखा जाए, इस केस में तो हम हालांकि वो उस केस के लिए, लेकिन हम इस केस में दिखा रहे हैं कि इफ नॉट entitled for the minimum wages act, then how the statement, तो when he was on part time basis establishment पहले
पार्ट टाइम कहाँ से बोल रहे हैं? इस
अच्छा।
रिकॉर्ड में पार्ट टाइम कहाँ से बोल रहे हैं आप?
हाँ ठीक है, हम वो इस रिकॉर्ड में नहीं है, ठीक है, हम वो इसमें नहीं कर सकते हैं, बट ही हैज नॉट प्लीडेड इन द प्लीडिंग भी। तो एक बार देखा जाए कि हमको हर महीने 1200 रुपया मिलता था, हमें
लिखे हैं 1200 लिखे हैं 1200 रुपए मासिक वेतन पर।
हाँ ये कहीं मैडम भी बोलते 1200 रुपया, लेकिन एविडेंस कहीं नहीं दिए कि ये मेरा सैलरी
आप
मेरी
cross
हमको
examine
कैश
किए क्या
मिलता
उनको?
था। हाँ वो तो
नहीं
नहीं
किए
हुआ,
ना,
हाँ।
शोकॉज भी
But
नहीं
in-
फाइल किए, तो उन्होंने जो भी बोला शायद दैट स्टूड एडमिटेड, उसको प्रूव क्या करना?
But evidence तो any fact which is made in the application
He has
that has to
deposed,
be supported
he
by
has
the
deposed
evidence.
before the court.
Evidence. Only oral
With
submission.
the WPL number 5900 of 2006. Heard the learned counsel appearing on behalf of the parties. This writ petition has been
सिर्फ इसमें
filed
reinstatement.
for the following relief. The learned counsel for the petitioner submits that the club involved in the present case
Doesn't come under establishment.
is not covered under the term establishment under Bihar Shops and Establishment Act. And there is no question of any sale or purchase and there is no question of any business, trade, or profession in club. She has further submitted that the concerned workman was working only for 4 hours a day in the evening and had worked for a short period from 1/1/2001 to 30/6/2002. And by the impugned order, there is a direction of reinstatement with full back pages. The learned counsel has relied upon a judgment passed by कौन सा judgment दोनों एक judgment reported in 1994 SCC online PNH 945
If is not in service.
क्या चीज बोल रहे हैं
उसमें बोला है कि if is not in service, if is not of cases, तो he is not entitled for minimum wages act.
ये तो मिनिमम वेजेस का
हाँ
बात
उसी
कर
का
रहे
तो हम DM खाली वो दिखाना चाह रहे थे कि if is not in service, he is not entitled for
हैं he
anything.
was discontinued ना
हाँ तो उसमें भी तो minimum wages act उसी में उसमें भी वही है मैडम, if is not in service, then he is not entitled for
इसमें
minimum.
मिनिमम वेजेस का डायरेक्शन है क्या पेमेंट करने में शॉप्स एंड एस्टैब्लिशमेंट
नहीं, हम वो प्रिंसिपल हम खाली दिखाना चाह रहे हैं कि if is not in service, उसका सर्विस वो तो एडॉप्ट पार्ट टाइम था या एडॉप्ट था जो भी था, तो if is not in service, if is not a permanent employee, he is not entitled for the benefits.
to
Whatever.
submit that she has relied upon the judgment passed by Punjab and Haryana High Court reported in 1994 SCC online PNH 945 to submit that any person who is not in service is not entitled to minimum wages. स्टे था यहाँ से
जरूर होगा मगर आई हैव अपीयर्ड क्वाइट लेट इन दिस केस शुरू से स्टे है एडमिट केस है
स्टे भी है
जरूर होगा मैं बिल्कुल नहीं तो हम नहीं थे उस समय हम तो लास्ट में
The learned counsel submits that the impugned order calls for interference. She has submitted that a review petition was also filed. The same was dismissed. एक और तीन चीज फाइल किए थे ना पिटीशन फॉर रिकॉल
रिकॉल फाइल किए थे
the learned counsel appearing on behalf of the respondent on the other hand has opposed the prayer and has submitted that in spite of repeated opportunities the petitioner did neither file any show cause nor participated in the proceedings, and even the workman who deposed before the concerned authority was not cross-examined. The learned counsel submits that there is nothing on record. There is nothing on record that the concerned workman was a part-time employee or an ad hoc employee. Rather, it was a specific case of the concerned workman that he worked during the period from 1/1/2001 to 30/6/2002 and at monthly wages of rupees 1200 per month as kitchen helper, but when he demanded wages when he demanded minimum wages, he was terminated from service without any notice and without
नोटिस तो मैडम वो नहीं होगा क्योंकि 6 मंथ से ज़्यादा जो काम करता है उसमें स्टैट्यूटरी ऑफ एस्टैब्लिशमेंट में बोलता है कि द पर्सन हु हैज वर्क फॉर मोर देन 6 मंथ देन नोटिस इज रिक्वायर्ड
6 months नहीं काम
आप
किया.
ही ना कर रही काम किया है
सॉरी आई एम रियली सॉरी आई टेक बैक
He has also submitted that the that no disciplinary inquiry and no allegation was leveled against the respondent. Still, he was removed without complying the provision of law.
पैरा 22 of my writ petition में also be quoted in my submission. पैरा 22 of writ petition.
ऐसे बीच बीच में क्या बोलते हैं? आपको नहीं सुने क्या? आप did you refer to para 22?
Submission लिखा रहे हैं.
आपका सबमिशन नहीं लिखा रहे,
मेरा
इनका
लिखा है
सबमिशन.
Sorry, I was just reading my.
आपको पता ही नहीं है क्या लिखा. ये डिलेड से फाइल हुआ है केस.
90 days beyond
90
तो पैरा
days
22 वही तो हम बोल रहे थे.
आपने कोई काउंटर फाइल किया ऐसे?
वही रेफर कर रहे हैं.
Have you filed any counter?
हम लोग मतलब सहमत हैं
Was the delay controlled? Was the delay controlled?
जस्ट
No limitation petition was filed as per the statement.
जस्ट
The same cannot be considered without condemnation.
नहीं डिले बिना कंडोम किए कैसे हो सकता है? नहीं ऐसा
ऑर्डर में तो नहीं दिख रहा।
एंटायर ऑर्डर शीट भी लगा हुआ है
हाँ वही देख रहे थे, वही देख रहे थे।
नहीं
Thing is, they never contested, they never raised this issue, my lord.
दे हैव रेज्ड द इशू रिव्यू में लिखे हैं रिकॉल में लिखे हैं
Just
छोड़ दीजिए कल लिखा है ये नहीं हो सकता दिस कैन नेवर हैपन It's passed the order without any
yes, madam,
petition
there is
for-
power to condone, but no order has been passed. That is the fact. I cannot justify that. And I have appeared also in this case, my lord Supreme. I had no Kalatama. Even today, I have no Kalatama.
Who is appealing?
I am appearing only because, my lords, the honorable court says that both cases are tagged and I should appear. Not your lordship, my lord, earlier also. The second case, I have got Kalatama, 4-9, or perhaps in this case only. Fresh Kalatama was directed to be filed.
तो अगर मान लीजिए डिले कंट्रोल नहीं किया है तो क्या ही करना है
नहीं कर सकते हैं लेकिन but that issue they never contested the case, my lords, and it will be deemed to be condoned. They ought to have contested. आप देखा जाएगा कि जब तक इनको नोटिस गया ही नहीं अपीयर किए और फाइनल ऑर्डर जैसे ही इनके पास पहुंचा विद इन 1.5 months they appeared and filed petition for review. So deliberately they are not doing that. और ये पावर तो है ही, even if, my lord, there is some procedural irregularity, it is not, my lord, substantive defect is not there. 90-day limit is there and plus 26 for a power है to condone the delay.
Power
It will be
without
deemed to be condoned.
without any application.
कोई ऑब्जेक्शन लेगा उसको तब ना उसको किया जाएगा. In my that is my submission. They have never objected. अब ये अचानक इनका जो कंडक्ट है वो देखा जाएगा कि जिस दिन इनका ऑर्डर हुआ है उसके within 2 months, less than 2 months, they have appeared and filed legal. That means that they are watching the proceeding.
Everything is same, but
Time and
without
again, अरे आपके से थोड़ा बहुत क्लब वाला से पता कि क्लब खुला होता है कि नहीं. हम बोल रहे हैं कि the conduct can be seen, my lord. They are not appearing despite several notices, and the moment final order is communicated to them, less than 2 months they have appeared and filed review petition. And
the
they
date of receipt of the notice of the order of punishment is also not there on record
yes. And thereafter conciliation took place. It is not that simply, my lord, the case was filed. My lord, see the annexure 1, how the case has been filed. First, I was not allowed to work. Then I raised this issue with conciliation. Conciliation was held on several dates. There also they did not come. Thereafter this case was.
कल ऑर्डर करेंगे morning
हाँ
में।
देख लिया, बहुत देर हो गया.
इसमें नोटिस भी हुआ था जो नोटिस का कहीं रिकॉर्ड पर नहीं है कि नोटिस वाज validly served and without recording that
Pose the case tomorrow for further hearing. Further learners counsel for the parties. Pose as the court time is over. Pose this case tomorrow for further hearing. 10:30 करेंगे. Monday.
10:30
Monday.
मंडे ना. हाँ ठीक है, वही बोले कल बहुत भगदड़ अपील हुई.
Monday.
43
क्या हुआ? अदर साइड कहाँ है?
वो हम दिल्ली का सर इंडिजिस
कहाँ है आपका?
इंडिजिस में है.
स्लिप कहाँ है? स्लिप
वो मैं फिर हम उसको नेक्स्ट वीक बुधवार को ले रखते हैं मैडम.
वो तो ऑटोमेटिक जाता है उसमें क्या
ऑटोमेटिक
करें?
रहेगा
मैडम,
बुधवार.
ये
automatic-
सेकंड हाथ में इसको कर दिया जाता है.
Today I take leave only to show the date which was notice was issued, but without giving any report that it was served to the party. Next date was fixed and order was passed. खाली वो date हम दिखा
कौन सा?
मंडे को दिखा देंगे.
इसमें
Date
ना?
note करके, हाँ. Date note करके.
नहीं वो एक आपने ये लिया है पैरा 22 में उसको
हाँ, 22 में लिया और एक और चीज़ है वो भी हम मंडे को दिखा देंगे.
हाँ ठीक है, उसको देख
उसको
लिया,
फिर से
हम
बात
भी
करेंगे.
देख लेंगे.
मंडे एट 10:30 10:30 बजे आ जाइए